Hi there, I'm Cam Sellings for Region Media. Well, most will know that a will or testament is a legal declaration of a person's wishes regarding the distribution of property or real estate once they have passed. What if, though, a will was to be contested? Let's find out a bit more about that and say g'day to Craig Edwards from Malagurnis Edwards Johnson. Hi, Craig.
Hi Cam, how are you going?
Good, thank you. So what happens if a will is contested?
Well, if a will's contested, it's a contest, obviously. It's a challenge to the will, the intentions of the person who apparently left the will.
Okay.
And I say apparently because it could also be that the will itself can be challenged.
Sure. And what are some of the situations that we might find where a will is contested?
Look, there are a number of them. A challenge to a will might occur if the person who created the will, the testator, or testatrix as she used to be known, has created a will when they simply didn't have the capacity to do so anymore. So an old person with dementia or somebody who was mentally deficient, who didn't have the mental capacity to really understand the nature of what they were doing. In those circumstances, the will itself might be challenged. In circumstances where a will is validly made, it could still be validly made, but the person who has created the will, the deceased, hasn't left adequately provision for those people he or she should have left for.
And when you are creating a will, do you see that often where people don't express their true wishes adequately enough?
Yes. There is that, but more so we see people intending to leave property, intending to create a will that leaves people out who you might otherwise have expected to take. And in those circumstances, the testator has to be advised to give careful consideration not only to who they're leaving part of their estate to, but who they are leaving out and why.
And so what are people who want to contest a will? What are some of the mistakes that you see those people making?
Well, if you want to contest a will, you should do so promptly. You shouldn't feel in any way awkward or embarrassed about making that first phone call through to an estate dispute lawyer. The earlier you deal with the matter, then the better the position is. Secondly, they may not gather up documents that are relevant, obviously the will itself or any documents that go to indicate the intentions of the testator. That's basically it, just a general awkwardness or embarrassment about it. It's a private matter. It should be dealt with relatively privately, although it tends to be the case that family members will become involved, but it certainly shouldn't be Camp A versus Camp B of a family.
And do you see that though? Do you see Camp A v Camp B?
Yes, there is an element of that, and we have to cut through it when we're advising the person who is likely to be able to validly contest part of the will.
Yep. Is everybody eligible? Anyone can test a will?
No. The overall principle, Cam, is that a sane person should be able to leave their property, whether they've done well in life or very well in life or only modestly, but they're entitled to, as an adult, leave their estate to whoever they like or to whatever institutions they like, a charity, a family member, a friend, so on and so forth. That's the starting principle. The second principle, which competes with that, is that society says, well, yes, you have the right as an adult to leave your property as you wish, but at the same time, society imposes some moral obligations for some people to be properly provided for in a will. And so it's that contest between those two principles that we deal with.
Does that surprise people when they come in and they approach you looking for information and advice and you have to tell them, look, you're just not eligible, you can't do it?
Well, some people, yes, some people are disappointed by that. Others already have some inkling that they are somebody who should have been provided for in the will, or that's their essential feeling about the whole process. And sometimes you need to explain to them that they don't come within those categories. In other cases, you can inform them of their potential rights.
You talked earlier there about Camp A versus Camp B, and there has the potential there for things to get very nasty and boil over. I'm sure in your long career you've seen that. But it is also a bit of a pressure relief on the community with some of the results that you're talking about.
Yes, you're right. It's my way of looking at it is this, that although it's an understated benefit of our legislation and our system, I think it's important that people do have that fundamental right to leave their property as they see fit. It's their life and they've experienced that life, and they're the best person in many ways to know who and why who it is they're leaving it to and why. But sometimes you'll have a situation where the failure to provide for some individual who might have expected a provision under a will becomes a matter of argument within a family, and that needs to be just dealt with by the lawyer quickly and cleanly, and people's expectations set properly.
Yeah.
It doesn't happen very much, but when it does happen, it needs to be put to bed.
It's almost a colliding of two worlds, isn't it? I mean, world number one, you have relationships and emotion, and it collides into world number two, which is the true letter of the law.
Yes, you're right, it does. And more so these days, I think, because we have now many more instances of separations, divorces, remarriages, second families, melded families, and so on and so forth. So, yes, you've got greater propensity for misunderstanding as to who should receive and why they should receive, who's entitled to receive, who's entitled to challenge.
Is it an interesting line of work to be in? I mean, we've only sat down here for just a few minutes now, and already I'm invested, and it sounds very interesting.
It's fascinating, not necessarily solely because of the application of the laws and what would appear to be some conflicting laws. So not just from a technical lawyer's point of view. I find it fascinating because it just means that you are speaking with clients in a very detailed and thorough and usually a very interesting sort of a way, because everybody's got a story to tell. Yeah. And I find that fascinating, and that's where the real rewards come in.
Yeah. And as we wrap things up, what's your number one piece of advice to anyone thinking about contesting a will if they find themselves in that situation?
I think, first of all, don't be embarrassed about the fact that you don't feel comfortable with the way that a will has presented. If you feel as though there's been some failure to provide where the testator should have provided, then pick up the phone and make the inquiry. Secondly, just gather up whatever documents or records you can at the earliest stage. And then thirdly, be prepared just to speak up fully and frankly to an experienced lawyer working in the area.
Sure. Well, Craig, thank you so much for joining us. It's been a fascinating conversation. I'm sure with all the levels of complexity, we could have sat here for hours and hours and finished off the conversation with a nice glass of red. No doubt it would have gone that long. But, mate, thank you so much.
Thank you, Cam.
Okay, Craig Edwards from Malliganis Edwards Johnson. For more information, the website is simple. It's just mej.com.au.